preserved to enable investigating agencies to send it for DNA tests. Minors can be discharged from the hospital after termination. But she be given proper care even after she was discharged, and regular checkups be provided to her. And she be provided medicine, proper diet, nutritious food as may be necessary for her health. These are the issues of concern which arise out of this case. The existing legal provisions, though MPP Act very clearly provides for medical condition of pregnancy in certain respects, it was not ordered in the first instance. That's the interest of the child. The case was considered purely under MPP Act, and it was never considered that she was a minor and she herself is a child. What do we do with her health and well-being? And possible risks related to the physical and mental health of the minor did not receive enough intervention from the physician. Termination of pregnancy and the trial of the pregnancy. And Ms. Aruna Kashyap, the presentation. Yes, how their contribution to the development of law around maternal life rights, as well as I asked you to speak about public-private partnerships and what is all around. To repeat what I said, I will briefly take you through some ideas for how HILM can maybe strengthen their contribution to the development of a rights-based approach to maternal health and reproductive rights. And I will also briefly touch upon public-private partnership. I think it's an extremely complicated area that needs tremendous amount of research, but we can apply some points from international law as well as Indian law. In terms of legal strategies, I think it's interesting. One thing is to look at legal strategies beyond public interest litigations itself. I think public interest litigations are critical. There are two things, as the Selector case sort of illustrates. I think one of the drawbacks of public interest litigation is structural, in that usually courts have just one day assigned to hear a public interest litigation case. It depends on the individual judge's fancy. When the judge is sensitive, he or she is willing to take up a particular case, and in some cases they are not. And so it sort of becomes a legal sort of huge battle that's protracted, where often lawyers are sort of biding time and not wanting to bring up a case if the judge is not sensitive. And on the other hand, for example, we have Justice Muralidhar sitting in the Delhi High Court, who is involved in 377 judgment as well as in the Lakshmi case. And if there is a very progressive judge, then strategically it would make sense to bring a public interest litigation before such a bench, because they're amenable to hearing. So one aspect is so in terms of planning public interest litigation, I think it's critical to look at which state, what is the bench, who the progressive judges who are serving it, then possibly push through some public interest litigations. And in terms of that, I think there are two, three critical areas where I think public interest litigation would make sense. One is looking at the recent maternal death audit guidelines that have been issued by the Indian central government. So, after a lot of sort of activism by the Indian groups, I think finally the Indian central government has paid attention to the importance of adverse pregnancy outcome monitoring. And what they have done is issue guidelines. But given that health is a state subject, what the Indian central government can do is limited in terms of its power. So they can only issue guidelines, and it's up to the state governments to translate these guidelines to a government regulation and ensure that it's implemented within the states. So I think what needs to happen over a period of time is monitoring to see whether different states are actually implementing these guidelines. So that's where I think HRLN can have a very, very good partnership with health rights groups to see that, what is the progress in each state, whether each state is taking up the maternal death audit guidelines issued by the central government, how far are they going to implement it in the different states, what are the problems that states experience, given 6 months down the line, have they taken any action, and if they still haven't initiated any action on these guidelines, then a possible public interest litigation to say that these guidelines are critical to the efficacy of the GSY, monitoring adverse pregnancy outcomes is critical, and the states are not taking the initiative, would be an area of intervention that would be required. The second aspect, where public interest litigation could play an important role, is linked again to adverse pregnancy outcome monitoring, as well as a related issue of early marriages, which contributes to early childbearing as well as maternal mortality, is vital registration in India. Interestingly enough, and I'll touch upon the Lancet study as well because that was brought up. The Lancet study, what it does is uses the vital registration system data from India and corrects it statistically. So one way of sort of questioning that is how much, and for example, at the Women Deliver conference itself, they said, the Lancet study actually gives estimates for maternal mortality in countries where there is absolutely no data. There is no data on maternal deaths. Or where there is data on maternal deaths, the data is extremely limited if you're drawing it from vital registration systems itself. And to that extent, how much or to what extent do you want statistics to play a role? Or alternatively, if you know that there are statisticians who are constantly going to turn to vital registration systems and correct it, the way to ensure that the projections of estimates become more and more accurate is to look at the first set of data that they're turning to, which is vital registration. And India has very, very poor vital registration systems, especially in the empowered action group states. Bihar, Uttar Pradesh, Uttarakhand, these are some of the states where the vital registration system is very poor. So one area for strengthening very concretely would be to look at birth and death registration under the Registration of Birth and Deaths Act. Because this will also directly lead to the enforcement of the Child Marriage and Commission Act in India. And a related issue, when we were doing research in Uttar Pradesh, what we found was there is some amount of effort to ensure registration of births, but not so much registration of deaths, which is critical because one of the things that was happening in Uttar Pradesh is that in rural areas there are not designated crematoriums or sites where bodies can be disposed of, which does present a public health issue. So poor communities were actually, where there was a woman who died during pregnancy, a reason why that death is completely invisible was because they were burying her body in the field or in their backyards because there wasn't any other place to go. So designating areas for as crematoriums in communities, which is culturally acceptable, is a way of visibilizing maternal deaths. So it doesn't go sort of completely under wraps in these areas. So I think Registration of Birth and Death Act, enforcement of that act is critical too. And in terms of looking at strategies beyond public interest litigations, to look at strategies legal strategies at the ground, to create a culture of yes, there's a standard and yes, the standard has to be enforced. I think the starting point for that is looking at the Roti Kalyan Samithis in the country. And one of the issues, which is a rights-based approach, which I think grassroots level legal strategies can push the agenda, is looking at the grievance redress powers of a Roti Kalyan Samithi and actually constantly taking complaints to the Roti Kalyan Samithi, and if they don't act on a complaint, to then take it up at a higher level and then take it up in the form of a petition. So I think the point is now to start I think there's a lot of documentation from health rights groups about what kinds of practices are either discriminatory or abusive treatment when women come into the health facilities. And I think the point there is to convert that into the form of a formal complaint and push the Roti Kalyan Samithis to actually exercise their grievance redress role. And if they're not able to exercise their grievance redress role, I think that's when it has to be followed up in terms of a writ petition. I mean, so it doesn't have to always be a public interest litigation. I think it will have to go through this channel to ensure that Roti Kalyan Samithis in all fairness are given a chance to exercise their grievance redress power. The point is also no complaints are ever brought before them in a formal way for us to then be able to say they aren't redressing grievances at all. So I think that's where HRLM can play a critical role, developing a format for complaints in consultation with health rights groups, widely disseminating this, because the challenge is also that there are far too many complaints and far too few lawyers in some of these districts. So enabling health rights communities to sort of file simple legal complaints without actually a lawyer having to be present over there. So a prototype for a complaint, a legal complaint that can be formed and is circulated widely where groups can use it and then HRLM can use it as documentation for further legal action would be, I think, extremely useful. So the other issue I'm coming But I think what would be very useful is to have, I think, a full deliberation over 1 or 2 days about this entire concept, with a lot of legal and sort of research preparation going into the 2-day consultation and this sort of idea to flag for further action. I think one of the critical issues in terms of public-private partnerships is its definition itself. I think there are 2 types of partnerships. One is partnerships with the non-profit sector, one is partnerships with the for-profit sector. And within the non-profit sector, usually it takes the form of training, devising modules, educating health rights workers. It takes different forms of partnerships. And with the for-profit sector, it could be direct service provision. Even within the non-profit sector, it could be the direct service provision, because there are NGOs that are helping run primary health centers in different states. So there is a sort of clear for-profit and non-profit sort of separation in terms of partnerships. And I think under international law, the problem is that international law doesn't look at the source of service provision. I mean, under international law, even if look at the general comment of the Community on Economic, Social and Cultural Rights, what they say is it's not about the type of provision of service, and even the Special Rapporteur on Health says they're not so much concerned about whether a public health provider is providing the service to a private health provider, but the quality of the service and whether the service is affordable, accessible, of quality and acceptable is what is important. So the regulation of the service is more important than the source of the service. And to this extent, I think that's where India lags behind. I think the regulation of the private sector, regulation of the public-private sector, the type of partnership is completely underdeveloped. And I think in terms of legal strategy, that's what's required. But I think while international law does present a very good avenue which we can use in local law is that all economic, social and cultural rights, especially health, will have to always make a progressive development. The development can never be regressive. So if we are able to show that a public-private partnership, for example, the one that was proposed in Uttar Pradesh, where they were floating a sort of it was a document seeking a partnership proposal from a private sector partner to take over hospitals, to take over district health hospitals, to take over community health centers and country health centers and run them, and categorize the service to type A, type B, type C, where type C would be with user fees. I think the point there is if we're able to demonstrate that charging a user fee for what was otherwise a completely free service would involve cutting back of services for poor women. And then if we can make a factual case where there's a public-private partnership and the effects of that is regressive, I think then we'll be able to challenge the partnership itself. So in terms of documentation and research,